can't prove or disprove that.
Sure. I mean, you could go to the shop and see if there's CCTV there of him going to the shop. Exactly. There's nothing of him going to the shop. Okay, so sorry, I'm here with PC Joe Dockery. Your shoulder number, sorry?
920.
920. So I'm inquiring about the assault that happened at the job centre. Sorry, the alleged assault, I should say. And I'm being told that it's being taken as a no further action due to, after being interviewed, the facility manager saying that it was self-defence.
Yeah, so that was his defence in interview. Evidential difficulties is our problem with it.
Right.
So we saw the video, and you guys as well have seen it. We have to physically see it. I know we hear like the audio. I've dealt with many investigations where it's been sort of like the footage you saw where it's pointed at the ground, shuffling around. And you can hear it. And I agree the language was vulgar, as I've discussed with you. But we have to actually physically see the assault.
But you know, in a common assault case, physical contact is not needed for grounds of common assault. The language and the verbal threat of threatening to cut my face off, that is a verbal threat that made me feel under threat of attack. Whether or not you see the physical assault, that is enough for a common assault. And that alone should be enough on evidential grounds to take it further.
The officer explains the case has been dropped due to conflicting accounts. However, the auditor raises an important legal point. Under UK law, common assault does not require physical contact. Causing someone to fear immediate unlawful violence can be sufficient. The alleged threat directed at his face appears to exceed reasonable self-defense, prompting a legitimate question. Why was that specific statement not pursued further?
Is that threat alone of, I'm going to cut your face off? That's not something you say in self-defense. Self-defense is if he's saying that he was defending himself, and that's saying, if you don't stop, then I'm going to defend myself. Not, what are you doing coming on my manor? I'm going to cut your fucking face off, you cunt. You know, that's what he was saying. So I do not understand how you can justify a no further action.
So,
is DS Ryan on duty at the moment?
She is, yes.
I would like to speak to DS Ryan, to Detective Ryan.
She's at Huntingdon Police Station.
She's at Huntingdon Police Station, at the headquarters or at the station?
At the station, she's at.
At the station.
I'm sure she can run through it with you the same as I'm doing.
Yep.
But just to reassure you as well, so the job centre, they've done an intervention with him and all of the staff there. So he was investigated internally there. I'm not sure what that investigation is, but what I've been told is that he's been given educational courses. He's generally sitting in the back role now. He doesn't really engage in the main office, but it's not been left with nothing happening at all. It's been more educational for the whole of the job centre, really, on how to deal with sort of situations like that. And the conversation I had is that they were on high alert that day, the day he visited. Right. Because the day before there was that attack in Liverpool. So, you know, whether it's true or not, they were they were on edge with the camera, all that stuff. So I know you're entitled to film, of course, public buildings, but they were telling me that they were on edge because the attack in Liverpool, the hospital a few days prior. So they were a bit jumpy.
That doesn't justify being followed around the corner from the site of recording.
The officer provides context, explaining that staff were on edge. While context can explain tension, it does not generally justify unlawful aggression. Being stressed at work may clarify emotions, but it does not automatically excuse following someone into the street and issuing threats. The explanation seems to shift attention away from the core allegation, which the auditor continues to press.
To be attacked as I was walking away from the building. You know, he's obviously premeditated that because it's not reactionary to me being in the presence at the job centre because it didn't happen at the job centre. No. So it's obviously premeditated as I've gone away and after, I can't remember the name of the officer, PC Holloway, I think her name was, after she left, and then I've realised that she's left without coming back to talk to me. So I've decided to leave the scene and he's followed me up a good 100, 200 yards up the street, round the corner. Yeah. You know, he's premeditated that he's going to follow me and confront me and make those threats, put me under fear of assault, which is enough grounds for a common assault at the end of the day. And no further action is, the way I see it, is you as the police
Yeah.
complying with a business rather than what's happened to a citizen.
Well, I know where you're coming from. I know you view it that way, but as I say, I've got to be impartial.
So can you explain to me why the verbal threat of assault isn't enough?
And I was going to add an addition. So it's in regards to sort of his defence. So I know you said he's followed you. He said you bumped into him in the street on happenstance. He was walking to the shop. Now the thing is, I know that sounds ridiculous to you.
Right.
I can't prove or disprove that.
Sure. I mean, you could go to the shop and see if there's CCTV there of him going to the shop. Exactly. There's nothing of him going to the shop.
Well, we've seen there's no cameras that cover where you were, where you two were, and ideally, if we had that, it'd be perfect. So he's saying you've bumped into each other on happenstance. I can't prove or disprove that. He's saying you've got into his face first. I can't prove or disprove that because you didn't have your camera rolling before that.
Sure.
That's my difficulty.
Sure.
I've had a discussion with the sergeant as well. We would want to take it to court, but the sergeant said it's not good enough to meet that threshold to take it to court. That's why it's been NFA.
The discussion reaches an evidential deadlock. To rebut a claim of self-defense, investigators would need sufficient proof to challenge it beyond reasonable doubt, a difficult task without complete footage. Even so, the principle of proportionality remains central. A response to provocation must match the threat faced. Severe verbal threats rarely align with proportionate self-defense. The reluctance to test this before a court raises further questions.
Right. So again,
his self-defense is because you've gotten in his face and he said that you've pushed him first.
Okay.
I don't know if it's true or not because I can't prove or disprove it.
Okay.
And then he's pushed you back.
So, okay, with self-defense, you're allowed to defend yourself within reasonable force, correct?
Yeah.
So if he's saying that I've got on his face and that I've pushed him first and that he's pushed me back, and then he's continued to say that he's going to cut my face off, would not be justifiable as self-defense. That is clearly a common assault. Whether or not he's initially used self-defense, which I will say isn't true, but again, you can't prove or disprove that. Fine, I understand that. Whether or not that's true or not, what happened consequently that you can see on video of him threatening to cut my face off, right? That's where it becomes a common assault, regardless of whether he defended himself first by pushing me back. Irrelevant. The point is that he threatened to cut my face off. That's not within reasonable force under self-defense. And it's not. You know that as well as I do.
Okay.
That's where I'm coming from, is why I don't understand that from that, in a common assault, it doesn't have to be physical. The verbal threat is enough for grounds of common assault. Is it not?
Well, I've had this discussion, and I've spoken to PC Nazim about it when he handed the investigation over to me. I had a chat with my sergeant about it. I tried as best as I can for you, but I can't. I don't have the overall decision. I don't have the authority to take it all the way to court.
So, do you say it's DS, Ryan?
DS.
DS. And she's permanently based in Huntingdon? Or
she likes to float about, but she's from Huntington, yes.
Okay.
And I'm sure she would be happy to speak to you about it.
Okay.
She's aware, because she was in charge of PC Nazim before, and handed it over to me.
Okay.
So she's well aware of the investigation.
Okay. So what's the process for appealing this decision? Obviously, you and your DS have come to an NFA. So how do I appeal?
If you'd like, I can get my DS to give you a call to discuss it. Does that
I mean, I'd rather, she can contact me and I'll set up an appointment to talk to her face to face.
You want to speak to her?
Yeah, because that's not a problem. I can go out to Huntingdon.
Yeah.
But I want to talk to her face to face about it. Because obviously, as you can tell from my accents, I'm chasing it up. I want this to go further because, I wouldn't be doing this if...
The auditor pivots strategically by requesting to speak with a supervising sergeant. Escalating up the chain of command signals confidence rather than avoidance. Individuals lacking credibility rarely seek deeper scrutiny. By challenging the rationale behind the decision, he reframes the issue from evidence alone to accountability within the decision-making process.
I were the one going to him and initiating this assault. That would be stupid of me if I initiated, because why would I want that to go to court where potentially I could be done for it? It just wouldn't make sense. So I think that with that verbal threat of whether or not you can prove or disprove who initiated, that verbal threat should be enough to constitute a common assault, and that enough should meet the threshold for it to go to court. Whether it goes to a magistrate, I mean, it wouldn't be probably enough for it to go to the Crown Court. It would probably go to magistrates, because of the lack of footage and of physical and lack of actual physical harm to myself, other than a few bruises to the head, but under the hair. But I couldn't get any pictures of that. But it should be enough to at least go to the magistrates and for them to hear it, rather than the police decide no FA when there's clearly a common assault in the footage, whether or not the contact was initiated by either party. Because am I correct? The common assault doesn't have to be physical. No, exactly. So that's what I'm not understanding, is why that threat isn't being seen as a common assault, regardless of who initiated, because it wouldn't be enough. That wouldn't be justified under self-defense. But
then I'll say I'll arrange it with the sergeant to have a chat with you.
Yeah.
Just so she can go through everything, because she's been aware of it from the start.
Sure.
Whereas I've picked up early March.
Halfway through, yeah. Well, more towards the tail end, but yeah.
Yeah, a lot more to tail.
Okay.
Yeah.
So he's still employed at the job centre, which is a shame, considering what he's threatened and what he's done. But and he's working, I wouldn't, if you had done that to a member of the public as a government employee, I wouldn't expect you to keep your job.
No, definitely not.
Exactly, you know what I mean? I don't expect that of anybody that's paid by our taxes to act that way.
Attention shifts to consequences, or the perceived absence of them. Public-facing roles typically demand professional conduct, even under provocation. The fact that the employee remains in post appears inconsistent with what many would expect following a serious allegation. The auditor signals potential escalation beyond policing channels, while the officer's measured tone helps keep the exchange constructive.
The fact that he's still employed, I'll be contacting, the MP that's in charge of DWP, making sure that they're aware of the footage as well. But yeah, if you can contact DS Ryan for me and get her to contact me, that would be grand, and we can have a chat over the phone and potentially arrange a face-to-face at some point to discuss it further and the appeal process.
Happy with that? Yeah.
Well, not happy about it, but appreciate your candour, and as I said, you've done what you can. Obviously, if I've got to take it up with DS Ryan, that's what I'll take it up with.
Yeah.
Alrighty. Brilliant. Thank you. Thank you, PC Dockerel. Lovely. Take care.
You too.
So guys, there we have it. It's, apparently DS Ryan has had the final decision on an NFA for the assault. It's not something that I was expecting. I understand where PC Dockery was coming from, saying that, if he's claiming self-defense in interview, they can't prove nor disprove that from the footage that I have available. However, as I was saying to PC Dockery, is that regardless of who initiated contact, if he's saying that it was me, why would I be so fervorously following this up with the police to take it further if I were the one who initiated and could potentially get in trouble for it? That wouldn't really make much sense. And why, and as I was saying, to PC Dockerel, that even if I did initiate it, which I didn't, then the common assault, which is clearly shown in footage of his threat to cut my face off, is not a reasonable amount of force or a reasonable threat.
In closing, 3 core principles stand out. First, common assault can include credible verbal threats. Second, Self-defense must be proportionate to the danger presented. Third, prosecutorial discretion can sometimes feel subjective, particularly in he said, she said scenarios. The central question remains whether a serious alleged threat warranted judicial review rather than dismissal.